So good afternoon, everyone. Thank you very much, Professor Mac, for that kind introduction. And thank you very much, everyone, for being here on this rainy day to attend this seminar. It's a great pleasure to be here in Amsterdam to share with you this work that I have been doing for the last few years. Today, the presentation is based on a book that, if PowerPoint will allow me to, technology will agree with me. Today's presentation is based on a book that I have co-written with a colleague at Melbourne Law School, Jacqueline Peel. The book is called Litigating Climate Change in the Global South, and the book will be published in March next year. I'm very happy to say that we submitted the manuscript about 6 weeks ago. So all we have of the cover is this. And we have yet to decide whether we want a uplifting image, or do we want a depressing image to communicate our views on climate change litigation in the developing world. But I'm very happy to say that our publisher has given us a clear deadline. We will be having the book out in March. So there we go. I'm going to start with some examples of what climate litigation looks like. Everyone more or less resorts to the classic definition of climate litigation as any case, whether it appears in a tribunal or in a superior court, where climate litigation is a central issue in the pleadings or in the decision, or is periphery to the decision. But what does it really mean? So I really want to start with just some examples before I launch into further discussion on this. I will speak for approximately 40 minutes, leaving the rest of the time for comments and for questions. I'll be very happy to take them. So the first case I want to start off with is Lahari and Pakistan, which was decided in 2015, in the same year that Argenda was decided in the Netherlands. But while Argenda led to what is known globally as the Argenda effect in climate litigation, where there's been a lot of awareness about what Argenda did for Dutch climate law, and for law, brought my water bottle. Lahari is a lawyer, but he also happened to be a farmer. And he was very annoyed and devastated by the fact that the Pakistani government had come up with all these really sophisticated sounding climate change laws and policies, but none of them was being enforced. He brought a public interest lawsuit, and the grounds in this lawsuit was that the state's failure to properly implement the national climate change policy and the supporting framework for the implementation of the climate change law policy amounted to a constitutional violation of his rights. Article 9, which is basically right to life, dignity and privacy of the home, Article 14, and the right to property, Article 23. The deciding court was the Lahore High Court, and they ruled that the governmental failure amounted to, offended the fundamental rights that Lahari had pleaded. The presiding judge was Judge Mansur Ali Shah, who described climate change as the defining issue of our times, and grounded the decision in constitutional theory, international environmental law principles, such as sustainable development and the precautionary principle, amongst other sources of jurisprudence. What is really interesting about Lahari and Pakistan is the remedies that the court ordered and the results of the case. Bearing in mind that Pakistan is a jurisdiction which has a long tradition of an activist court that has given several remedies for the protection of socioeconomic rights, such as the right to housing, the right to education, and the right to environment. This set of results has to be understood in that context. Judge Mansur Ali Shah basically, on the witness stand, heard from the government that there is a Ministry of Climate Change, but the Ministry of Climate Change had no one to talk to. Nobody wanted to work on climate change. When they wanted to come up with a climate change plan that had to be implemented, well, Ministry of Trade says, not my business. Ministry of Transport says, not my business. So how are you going to do that? So Judge Mansoor Ali Shah said, all right. He directed to the relevant government agencies to each nominate a focal person to work closely with the Ministry of Climate Change. He established an expert climate change commission to assist the court in monitoring the government's progress in implementing the national climate change agenda. And this is important because this is a writ of continuing mandamus. It ran for nearly 3 years. The court basically had this expert commission deliver a report almost every 2 or 3 weeks on the progress of the government in implementing this work. Finally, in 2018, 3 years later, the court and the commission agreed that the remaining items on the agenda had been tackled, and therefore the commission could be dissolved. When I describe this case in the United States, they call it judicial review on steroids. Terrible. Now, the other case I'd like to share is the Tabametsi case. This is often known as the climate litigation lawsuit of South Africa. It is a case that is brought by an NGO known as Life Africa, challenging a decision by the Minister of Environmental Affairs. And this decision was to award the authorization for the construction of another coal-fired power plant. This case was filed just after the ratification of the Paris Agreement by the South African government. Life Africa's case theory was this was entirely disaligned with the net zero targets of the Paris Agreement and would keep South Africa stuck in a fossil fuel trap when the energy transition required South Africa to be looking at renewable energy options. So this was a classic judicial review, and the Pretoria High Court ruled that the minister was obliged to consider climate change impacts, but had failed to do so. As such, the invalid and struck down. In addition to that litigation, there was litigation on several other fronts. There were challenges on the water use licenses, challenges on the air pollution emission licenses that have been awarded to the plant, and energy regulatory permits. This is what is often seen as a litigation strategy that combines the litigation on different arenas or different fronts in order to stop a project. In other words, strategic litigation. There was also a major campaign of community mobilization, shareholder activism, and pressure on the banks. Several South African banks, as well as international banks, eventually decided to pull out of the project. The decision itself, on appeal, the Minister of Environment actually had the last word. It was ruled that the ministers, the ministers, on appeal, the minister basically submitted that she had considered climate change impacts. But the principle of sustainable development meant that she had to balance that against other considerations. And other considerations meant that the project should go ahead. But the project has not gone ahead because the community mobilization has meant that the project lost its social license to operate. I'm going to give you another example of what I describe as a transnational case. It's not a classic Global South case. It's not a case that I consider in the book per se, and I'll explain why later. Because this is the kind of litigation that is brought by citizens or plaintiffs who are located in the Global South, who seek to bring cases in the developed countries, in the courts of the Global North. And my example is Tasmania and others versus Holcim. On 1st February of this year, 4 inhabitants of the Indonesian island of Pari formally lodged a lawsuit against the Swiss cement company Holcim. The plaintiff's request is that Holcim reduce its carbon dioxide emissions by 43% by 2030, that Holcim pays loss and damage for its role in the climate crisis, and pays damages. It is very radical because it's not been asked before by a group of people from a Global South jurisdiction. What are they asking for in terms of damages? A study by the Climate Accountability Institute, led by Richard Head, has shown that between 1950 and 2021, Holcim released more than 7 million tons of carbon dioxide. This amounts to more than 0.242% of all global industrial carbon emissions since the year 1750. The plaintiffs seek just a small amount, $3,600 each, as compensation and contribution to the cost of flood prevention measures. How did they come up with the number 3,600? Well, basically what they did was they calculated the total sum for the value of the compensation. And then they said, well, if Holcim is responsible for 0.242% of global emissions since the start of the Industrial Revolution, its share of the cost of compensation will be proportionate to its contribution causing climate change. The case is currently proceeding through the Swiss courts. It's only been filed in February. The court is watched with great anticipation because of the precedent value of such a case against a global corporation, one of the largest construction companies in the world. So these are the three examples I'll give of climate change litigation in the Global South, with Tasmania being a bit of an outlier because these are cases which we call the transnational cases, filed by Global South plaintiffs, but in the Global North courts, such as the United Kingdom, Netherlands, Spain, Switzerland, etc. Why did we decide to write this book? Well, first of all, in the work that we've been doing on climate change law and more broadly on climate change litigation and more broadly climate change law, Jackie and I found that there was a significant gap in the academic discourse, mostly Western, on climate litigation. And I remember once attending the conference where someone said to me, there's no such thing as climate litigation in the rest of the world. I was like, oh, it's a challenge. I love it. So that was the starting point for the book. I asked Jackie, how can there be no litigation in the rest of them? Now, what happened was an initial intuition, which became our hypothesis for this book. Climate lawsuits were being filed, but they were not being picked up by the media, by academics, etc. There were a couple of reasons why this might be the case. The fact that these cases are being litigated in non-English speaking jurisdiction meant that they would not be picked up by global media, which tends to report in English. Right? Climate litigation in developing countries might also not be viewed as such because these cases do not bear the same characteristics as climate litigation in the global north. So that was our starting hypothesis. The background to this project, we started writing in 2018 and published in 2019 a paper called Transnational Climate Litigation, the Contribution of the Global South, to the American Journal of International Law. We're proud of this because it was the first time that an Asian surname apparently had appeared on the cover of SGEL. It's very big news on Twitter apparently, but I'm not here, so I don't know. In this paper in SGEL, we considered 34 cases as our data set. In this book, we consider 128 cases. What explains this significant jump in our data set? First, there has been a tremendous growth in climate litigation between 2019 and 2023 this year. Secondly, we have, of course, improved in our data collection methods. We've also received the support of an increasingly dense collaborative networks that have given rise to what can be described as a global climate litigation community. Now, the 128 cases does not include the growing number of cases with truly transnational dimensions, as I mentioned. For example, cases that have been filed in Europe by multi-actor coalitions challenging fossil fuel projects in Africa, and cases in the International Tribunal, such as the ongoing request for advisory opinions in the International Court of Justice and the International Tribunal of the Law of the Sea. Where is climate litigation happening in the Global South? This is a list of all the countries where climate change litigation is happening in Asia, Africa, and Latin America. The countries which are highlighted in red are what we call the front-runner jurisdictions. These are the countries where the highest number of cases has been filed and decided in those regions. So India will be the front runner, this jurisdiction in Asia, South Africa in the region of Africa, and Brazil by far the front runner in Latin America. Now, when we talk about the global south, it is a huge catch-all description. And I have had discussions with several students in one of my research seminars where they did not like the use of the term global south because of its connotations. And I said, I actually like those connotations because, like it or not, they still exist. Let us not pretend that the north-south divide does not exist. If you think it does not exist, please spend some time in the global south. Now, what, however, should be clarified is that we're not seeing climate litigation across all of the global south. We are seeing climate litigation in a subset of countries in the global south, often referred to by economists as the middle-income countries. They face challenges of maintaining sustainable economic growth, trying to deal with income inequality, environmental degradation, providing a safety net to their citizens, to dealing with globalization and just transition, all sorts of issues. But what is important is that these social conflicts take place in an environment where there are institutions that are considered good enough to encourage citizens to go to the courts to seek a remedy. When we look at the Global South docket, we basically see about 66 cases in Latin America and the Caribbean, 46 in Asia, and 16 in Africa. Now, I could talk a little bit about methodology, but I probably won't bore everyone with methodology. I'll just say a little bit because it's actually something that might interest some of you. The most important thing is when we talk about sources, we basically rely on the two main databases, the Grantham Institute and the Sabine Center's database, but also supplemented with our own trawling of information through our networks. And that's actually been very, very critical because the databases are not comprehensive, and it's not of a criticism, because these databases are also limited by the fact that they have limitations in their algorithm and also their methodology. What cases do we include? We include what I call core and periphery cases. So cases where climate change issues are central to the litigation or the dispute, or where they're subsidiary to the other arguments, such as climate change arguments being run parallel to an application to challenge an environmental impact assessment. We exclude incidental cases where climate change arguments are raised or climate change is mentioned in passing. And do we include cases which do not mention climate change in the court documents, but we know through our interviews and through other information that these cases are being filed to address climate change? And the answer is no, because we just don't have the ability to say that we can't rely on that as a basis for including these cases. Controversial in itself, we can talk more about that. What did we code these cases for? We were interested to look at who were the plaintiffs, who are the ones who are bringing these climate cases, who are the ones being sued. Are these cases core cases or are they periphery cases? In the sense that to what extent the climate jurisprudence is being developed in one direction or the other. We looked at the legal avenues being pursued. We looked at the extent to which the public trust doctrine was utilized. We looked at the utilization of rights-based arguments. And lastly, the extent to which the Paris Agreement was referred to and the extent to which national climate change laws were relied on or challenged. Now, if we look at the cases, I think the most interesting figure, however, is only at the bottom, 54.69%. Well, first of all, if you look at the number of cases, what I always think is the most interesting is the last column, because it kind of tells you the leaning. Well, of course, the numbers are also a little bit, it's not very easy to deal with percentages with a relatively small data set. But what you can see is that there are more periphery cases. than court cases. And this is something that we try to explain in our book as to why that is the case in the global south. Rights-based litigation has taken off globally, and this is definitely the case in the global south, particularly in Latin America. If we look at Latin America, the number of cases that are rights-based, which is the gray column, is quite high. And in fact, it's more often than not that rights-based arguments are relied upon by litigants in Latin America. We also wrote a chapter on trying to map out who are the actors in the global south litigation space. This was interesting to us because we felt that there was a significant gap in the literature on climate change litigation broadly about who were the actors in the space. And this is important to map out who were the ones influencing the development of climate litigation. So amongst the actors that we focused on, we looked at the role of NGOs, we looked at the role of funders and philanthropy, then we looked at prosecutors and regulatory agencies, lawyers, youths, and indigenous peoples. We were also looking at while mapping out all these actors, we also saw certain interesting patterns in the way these actors carried out their work in the space. And we basically decided that what we saw were 5 dominant modes of climate litigation in the global south. The first mode refers to the grassroots activists. The grassroots activists, this is typology, so it's basically like titles, it's like stereotypes, I guess. But I find them quite helpful in trying to understand who does what in the space. Grassroots activists really look at a lot of the NGOs, which are grassroots and domestic NGOs who bring climate litigation in their home countries. Contrary to expectations, everyone always hears about how Greenpeace sues, blah, blah, blah. But actually, contrary to expectations, almost 3/4 of climate litigation in Global South is actually brought by grassroots or domestic NGOs. This is not to say they do not work with global NGOs. This is not to say that global NGOs are not supporting the work of domestic NGOs. But at least on paper, what we know is that most of this litigation, 75%, is filed by domestic and grassroots organizers. This is particularly the trend in India, where there is a long history of public interest litigation in the environmental sphere, and so a lot of grassroots activism in this space. The hero litigator, well, the classic example I can think of is someone like Melinda Jenke. Melinda Jenke is from Guyana, and she is single-handedly responsible for filing all the climate lawsuits in Guyana to challenge the opening up of Guyana to oil exploration. A hero litigator tends to be someone who fights that seeks litigation by funding litigation. And we see quite a lot of that in the Global South. A lot of the cases would not happen without the appropriate amount of funding that is necessary to engage in litigation. The fourth is the engineer. The engineer is the NGO or the plaintiff that is seeking to engineer a certain result by replicating a certain strategy. So for example, if you had someone like a gender that has had a successful case and is seeking to replicate the success of that case in multiple jurisdictions, we see that, well, we call that entity the engineer. What we were quite interested, what we found was that there's actually very little evidence of an engineer at work in the Global South. there are one or two examples, but by and large, when there are entities like Agenda that want to try to share and to replicate the success of Agenda, it's more through local partnerships with entities on the ground to bring the cases, rather than to replicate the success by almost like a legal transplant model. And the last, which is actually very interesting, because this is a mode that does not really exist in the global south, north, is the enforcer. Much of the litigation in Brazil is brought by the public prosecutors. And in Indonesia, we also see quite a number of the litigation being brought by the environmental ministry, seeking to enforce forestry and mining laws, and incorporating climate change arguments in those enforcement actions. So that's the fifth mode that we find really that we discuss in the book. This is a chapter where we ask ourselves, clearly we all understand what are the conditions that would support the emergence of climate litigation. So writing this chapter felt a bit like writing a consultancy report. Was that something that we wanted to do? But we thought it was actually really important to actually really, go through the process of speaking to the people, going through the literature, and actually, asking ourselves, what are actually the conditions that support the emergence of climate litigation in the global south? Well, first of all, very clearly, access to justice. Broad standing rules and the removal of barriers such as high court fees and security of cost orders. So if you have access to if you have very narrow standing rules, for example, in my home jurisdiction of Singapore, climate litigation is a non-starter. It's really difficult to even get through the first hurdle. Secondly, hefty court fees. That is a no-brainer. If Shell brings in 4 King's Counsel at a preliminary hearing, that's your court fees in 7-digit figures, right? So you're going to put yourself up for a big, some really hefty litigation there. What we also found was that it was very helpful and important to have judges who are receptive to arguments that use existing environmental and natural resources laws as the basis for litigating about the climate. I sometimes think we should put away the word creative because it's not that creative, but it's a matter of personal judgment, right? If you're extremely conservative, anything is creative. So what we found was that we were inspired through conversations as well as the writings of Judge Brian Preston, who is the Chief Justice of the New South Wales Land and Environment Court. And in his writings, he talks a lot about the need for climate conscious lawyering. And there's also the need for climate conscious judging. What does that mean? In his view, the idea, and that's something that we subscribe to as well, the idea that the judges see that litigating climate change requires appreciating that existing jurisprudence has to be interpreted in light of the climate emergency. We see that in many cases that is not happening, but we also found that as a really important condition supporting the emergence of climate litigation. Well, of course, if you have climate change laws and environmental laws on the books, then at least you have the legal stock to start litigating. But we also found that just because a jurisdiction does not have a climate change act does not mean that climate litigation cannot happen. Constitutional protection of the environment is a very significant ground for, especially in the last few years, as the global community recognizes the fundamental right to a clean environment. This constitutionalism has also provided more a strong avenue for climate litigation in the global south. And an active civil society. Given that the vast majority of approximately 85% of climate litigation in the global south is brought by NGOs, an active civil society is really important. And in countries where civil society faces threats or is facing increasing control, that is often going to be seen as a threat or a change in the circumstances that might hinder the emergence of climate litigation. Now, we spent a bit of time looking at what are the key characteristics of climate litigation in the Global South. Because the initial hypothesis is that climate litigation in Global South may not be picked up because it's not looking like climate litigation in the Global North, which everyone has been writing about. So we decided that, okay, based on our understanding of the 128 cases and more broadly, what we see as broader trends, there are a few key characteristics that we can try to tease out. There are not stark characteristics like this is happening in the Global South, this is not happening in the Global North, but it's a bit more of a sort of a spectrum. So the first thing that stands out very clearly about climate litigation in the Global South is the prevalence of rights-based claims. This is happening in the Global North, of course, as you can see with the current cases before the European Court of Human Rights, for example. But what is really a stark is this in the climate litigation in the Global South docket is that it's very prevalent. And this is because many constitutions of Global South jurisdictions contain environmental rights, and the right to life, which is interpreted to include the right to clean environment. And some constitutions, such as Ecuador and Colombia, also include the protection for rights of nature. In the Global South, moving on to the second characteristic, there is a firm preference for the enforcement of laws and policies that already exist, rather than pushing for new or more ambitious climate laws. We see in the submissions that oftentimes plaintiffs are trying to address what they perceive to be the more fundamental drivers of climate change, such as land grabbing, deforestation, violation of mining laws. This is where you don't see the kind of cases where they're pushing for the government to adopt a new target or a better target. A lot of the litigation is what we consider less high profile in that regard, but more about enforcing the laws that already exist. We use the term stealthy climate litigation to describe the kind of litigation that happens in the Global South. What does it mean that it's stealthy? Well, first, it advances very cautiously and quietly, not standing on the top of the building shouting that we're going to sue the government. Why is this done? It's done to dilute the political potency of climate change issues and to avoid political question doctrine. The idea that these climate change cases should not be litigated or should not be addressed by the court because they are political issues and therefore outside the remit of the court. It's also necessary to advance stealthily because there is a tradition of judicial restraint and limited judicial review in certain jurisdictions. So we found that in a lot of our discussions with NGOs, it was seen as strategic to not shout that you're litigating about climate change, but also to earn the public support by combining climate change concerns with environmental concerns that are very real to the people on an everyday basis, such as poor air quality in the cities, such as New Delhi, Bangkok, Kuala Lumpur, which I've seen all sorts of cases that try to tackle air pollution and climate change in the same lawsuit. So this is the last chapter. It's the so what chapter. So what if all this litigation? Does it do anything apart from anything? Yeah, so what's the impact? And this is a sort of the million-dollar question because it is very hard to assess impact. So I'll start off with a few disclaimers. That's a typical lawyer you are. First of all, it's hard to assess impact because several of the cases have only been filed and decided mostly from 2015 onwards. So you have a very short time period of almost just 8 years to really study impact. Secondly is that we are very, very clear on this. Jackie and I strongly believe that impact is a qualitative assessment, not a quantitative assessment. It's a qualitative assessment because what is success? has to be defined in each case, and it does not look the same every time and in every jurisdiction. Therefore, we ask ourselves, when we look at impact, we ask ourselves whether the outcome of these cases actually help to address the problem of climate change in a meaningful way. And we talk about impact in four different types of impact. We basically decided that in this chapter, what we could do was to kind of trace the developments of a number of leading cases. So we look at the Lahari case, we look at the Of-Life case, we look at the third would be corporate accountability cases. We're already seeing growth in that area in the global north, the US, Australia, the UK, the Netherlands. And we expect to see more of these cases. And finally, the transnational cases where global South plaintiffs are going to try to seek redress in the global north. And with that, thank you very much, and I look forward to discussing with you. Thank you.